Welcome once again to Lehto's Law. Here's Steve Lehto.
A federal appeals court just issued a ruling that somehow has kind of gotten underneath the radar. And Michael sent me a note and said, Steve, I found this story in an obscure little corner of the internet. Is this true? Did this really happen? And the answer is yes. And rather than going to the story in the little obscure corner of the internet, I just went and pulled the opinion, because this Court of Appeals opinion is only 4 pages long, and they use really wide margins. So it's a short opinion, okay? Leonard French could do this in 3 minutes. That's how short the opinion is. But it's an amazing opinion because it suggests that municipalities, if they don't want to, don't have to post no parking signs, meaning that you are presumed to know where you can and cannot park if the municipality chooses to do that. Now, we'll get there, and I'll admit that that's a little bit of a stretch in the sense that no one's doing that. However, this taken to its logical conclusion could lead to that. It's a case called Lewis versus Alsip, and the village of Alsip is in Illinois. And it's from the 7th Circuit Court of Appeals. It was argued in January, and it was decided just a couple weeks ago. The judge's opinion begins thus. Shelley Lewis left her car parked on a public street in the village of Alsip during a snowstorm. She was fined $50 for violating an ordinance that prohibits parking on any street if more than 3 inches of snow has fallen in the preceding day. So there's a statute on the books that says you can't park on certain streets depending on how much precipitation has fallen the day before. 2.5 inches, you're good. 3.1 inches, that's against the law. So the ordinance bans parking on any primary snow route if more than 1 inch has fallen within 12 hours, and requires all primary snow routes to be identified by signs. So there has to be a sign saying whether it's a primary snow route. However, the law does not require them to notify of these secondary snow routes. So the street where Lewis had parked was not posted as a primary snow route, therefore was a secondary snow route. Trust me, this is all going someplace. So she got the fine. She could have fought it in court, but decided to fight it in federal court, arguing this is a violation of, in essence, due process. So instead of seeking a remedy under state law, she filed a suit in federal court under 42 U.S.C. 1983, contending that the village violated the due process clause of the 14th Amendment by failing to erect signs on every block of every street telling drivers when snow requires them to remove their vehicles. That contention flopped in the district court. So this court on appeal actually describes the lower court denying her motion and her request for relief and said it flopped in the district court. The case was dismissed as legally deficient by the lower court. And then this court writes, the district judge was right. The due process clause requires governmental bodies to make laws available to the public, but not to ensure that everyone knows all the rules. Generally, a legislature need to do nothing more than enact and publish the law and afford the citizenry a reasonable opportunity to familiarize itself with its terms and to comply. And that's a case called Texaco versus Short, 1982. So the city can simply adopt the rules and do something that gives the people a reasonable opportunity to familiarize themselves with the rules. The maxim that ignorance of the law is no excuse sums up this perspective. So, if they don't have to put up signs regarding the snow route, they wouldn't have to put up signs regarding, no parking on Wednesdays, or no parking Monday through Friday from noon till 1. They would not have to do that as long as they've passed the rule and afforded the citizenry a reasonable opportunity to familiarize themselves with the rule. Now, they do point out that some statutes require prosecutors to show that a person knows about the rule, and that, for example, would be a situation where a statute says it is unlawful to knowingly do this, okay? And so if you can do it, they have to prove your state of mind and so on. And there are situations where there are also rules that are self-referential, meaning that if somebody knows about this and still does it, they're in trouble. A great example of that also might be, say, a restraining order from a court that says once they've been served with this, they can't do such and such. Well, until they're served with it, they can, presumably. So that is the legislative exception. However, here's the thing. Lewis asserts that traffic regulations are a special situation as a constitutional matter, but the court says we haven't found an example yet, and we find that traffic laws are not exceptional. They're like anything else. We don't care. And by the way, this isn't really a traffic law. It's a parking law. Technically, when you're parked, you're no longer in traffic. So here, the court writes, the statute or regulation is adequate in and of itself as long as it is clear. So the municipality can pass a law that is clear, put it on the books, maybe pin a copy at the bulletin board down at the community center, maybe mention it in a couple newspaper articles, but not do anything else with it. And I think the court is wrong here, and there's a reason for this, is that most people would understand that building regulations don't get posted everywhere. I built a house on a piece of property. How was I supposed to know? They never posted the building regulations on the property. You'd understand that there's building regulations. You got to go look at them or find them and go read them. They're not going to be posted. However, parking rules, most people, I think, assume that parking rules are posted. We've all seen those signs where there's a pole and like 6 signs with all kinds of stuff. On holidays, this. Monday through Friday, this. On snow days, this. On this. And people assume that parking regulations are posted. And it makes sense because if you don't live in the town of Alsip, how would you know what their parking rules are if you come into town and need to park? You'd assume, oh, I see a bunch of parking signs. As long as I obey those, I'm okay. No. You've also got to familiarize yourself with the rules passed by Alsip recently. Drivers know that many traffic rules are not set out on signs but still must be obeyed. But some rules obviously are. For instance, you expect a speed limit sign to be posted if a speed limit is different than whatever the general statute is for the state as regarding its minimum speed limit. However, it's important to note that there is a case that appears to be right on point from the U.S. Supreme Court. And this court, the Seventh Circuit, specifically says we're not going to apply the Supreme Court rule because it appears to be such a rarity, and the Supreme Court itself hasn't used that rule in so long, we're going to consider it fallow. Fallow. That's their word, not mine. So the case is a case called Lambert versus California. Lambert versus California came out in 1957. And in that case, Los Angeles used to have a city ordinance that if you came to town and stayed for 5 days or more, I guess it's probably more than 5 days, and you were a felon, a convicted felon, you had to go and register yourself. We don't hear about laws like this anymore. It would wreak havoc on a town like Los Angeles. But the law said that if you come to Los Angeles and you're there for more than 5 days, you better register as a felon. So Lambert came to town, spent more than 5 days there, got picked up on something else, and they said, wait, how long you been here? More than 5 days? Did you register? So Lambert was fined for violating the Los Angeles rule on a registered felon being in town for more than 5 days. And the Supreme Court struck that down and said, and this is the operative language, as we like to call it, where a person did not know of the duty to register and where there is no proof of the probability of such knowledge, he may not be convicted consistently with due process. And so that right there sounds like, gee, I come into town, I see a whole bunch of signs regarding parking, but nothing mentions what would be right now, as far as I can tell. I park and you go, no, you got a ticket. You didn't know about the law, but it's not posted. Doesn't matter. We don't have to post it. Wait. Lambert versus California, where a person did not know of the duty to register and where there is no proof of the probability of such knowledge, he may not be convicted consistently with due process. What are the odds that someone coming into town is going to know that on a secondary snow route, if there's more than so many inches of snow, they can't park? And by the way, it requires like detailed meteorological knowledge to know this because you got to know whether it's 1 inch or 3 inches. Like I said, 2.5 inches, no. 3.1, yes. So the question you have, I'm sure, is the one I had. Why does the Seventh Circuit choose to ignore the Supreme Court, and they appear to be addressing something that is so parallel you think they'd be binding precedent? The Supreme Court has never applied the holding of Lambert to any other case other than Lambert itself. A dispute about parking rules is not an apt occasion to extend a novel constitutional doctrine that the justices have let lie fallow for 65 years. So they're basically saying this rule is so old, we're not going to abide by it. Now, I got news for you. In the grand scheme of age, when it comes to the Supreme Court, 1957 is not exactly archaic. I can find you cases from the Supreme Court prior to 1957 that are still relied upon today as good law. And the Supreme Court itself does not put expiration dates on their rulings and say, oh, this is good law until such time as it expires, sell by, No, doesn't do that. And so they're saying that because the Supreme Court has never followed Lambert since then, no one else needs to. Where'd that rule come from? And then it says, a dispute about parking is not an apt occasion to extend a novel constitutional doctrine. Well, a dispute about parking? What if this was a more important dispute, you'd do it? Do we really look at constitutional law and say, oh, there are little constitutional violations and there's big constitutional violations? Because generally speaking, most people in my audience, and I can speak for my audience on this one, because I read the comments, my friends, and most people in my audience will tell you a constitutional violation is a constitutional violation is a constitutional violation. It doesn't matter how big or small it is perceived to be. And so the idea that somebody appears to have a very good case on the idea of due process and notice sounds like that would be something that you look at and go, well, it might be a small case, but the principle is large. And I will cite myself on this. I did a video a while back where I pointed out the smallest thing I've ever gone to court for. And I titled the video something to that effect. And I went to court and spent half a day in court fighting a parking ticket because I was right. Now, I'm not saying that that time was well spent in the sense of I'm an attorney. I can go to court and make more money in half a day than I made that morning fighting a ticket for myself. Because all I saved was the cost of the ticket. And I could have made more money at my office. But I did it on principle. And I actually had a lot of people comment that video and say, Steve, you are underestimating how important this question was to call it a small thing. And I merely meant that a traffic ticket and a parking ticket and a crime and a misdemeanor and a felony, if you were to put all of these things on a sliding scale, a parking ticket is pretty much down near the bottom of what you consider to be important. I'm not saying it's meaningless. I'm not saying it's unimportant. I'm merely stating that of all the things I've dealt with in my life, that parking ticket weren't the biggest thing I ever dealt with. But it was the principle. And principle can be large even if the subject matter is small. So here someone comes to town. They see parking signs all around dictating where you can park, where you can't park, all kinds of stuff. But nothing mentioning snow. So she parks, and unbeknownst to her, a certain amount of snow fell in the last 12 or 24 hours. And it's apparently something that the locals are aware of, presumably because it was passed by their local council. And it was never posted on a sign, even though most people think parking regulations should be on parking regulation signs. So I think it's a strange case. I think it was decided wrongly. And if it does come down to it, I think that parking regulations are special because most people think, can I park here? I'll look for a sign. And there are all kinds of other things in life where you ask yourself, can I do this? But you don't automatically look for a sign, right? Getting back to my building regulations, the building code. I wouldn't expect that to be posted anywhere except at City Hall, where I can go look at them, or on the internet put up by City Hall. Right? But parking regulations, traffic regulations, those are the things we expect to see signs for, certain things. Like U-turns. Can I make a U-turn or not? Depends on the state you're in. Some states say it must be posted, might not be posted. And I understand that changes a little bit from state to state. But the point is that they are often governed by signs. And I think if you said pick one thing that's governed by signs, people say, oh, parking regulations. That's the one. That's the one. So it's a crazy case, but technically speaking, following this through to its logical conclusion, every city in the 7th Circuit right now can remove all of their parking regulation signs and leave it up to you to know what the rules are. And if you want to object and say, well, hey, it's a due process problem. I didn't know. Oh, it's not our job to tell you. It's only our job to pass the law and make sure the law is clear and understandable should you actually read it. And so that's the problem with this case. So Michael, thanks for sending it. The case is called Shelley Lewis versus the Village of Alsip, Illinois. I will put in the comments section below underneath the video a link to this opinion. It's only 4 pages long. And I'll also put a link to the parking ticket fight case video that I put up a while back. I'll put that below as well. And otherwise, I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Tomorrow isn't what it used to be.